Welcome once again to Lehto's Law. Here's Steve Lehto.
I did a video a while back entitled Worst Judge Ever. And I qualified that and said, there are bad judges out there. I'm simply referring to her as this because I've been in front of her and had witnessed her behavior and knew that she was bad. But people have since then sent me other stories and said, well, Steve, here's a bad judge, here's a bad judge. And there are bad judges, like there's just bad anything. There's bad lawyers, there's bad people on YouTube, there's bad people in every profession, okay? You're not going to get a profession where every single person is the best they can be. So out of Cleveland comes a story sent to me by Patrick, George, and Dennis. And Cleveland.com published it. Adam Faris wrote it. Headline, Cleveland Judge Pinky Carr should be suspended 2 years for unprecedented string of misconduct, according to the state disciplinary attorneys. And I mentioned before that the bar associations often have something overseeing them, like in Michigan, it's the Attorney Grievance Commission. But then there's the Judicial Tenure Commission that oversees judges. And so in Ohio, they have the same kind of thing. And here's what happened. State disciplinary attorneys recommended that Cleveland Municipal Judge Pinky Carr serve a 2-year suspension after an investigation accused the judge of committing an unprecedented amount of misconduct. And I know some people are going to say, Steve, she's off the bench for 2 years. Doesn't that mean that 2 years and a day from now she can get back on the bench? Theoretically, but you have to understand that it depends on when her term runs out and if she has to run for re-election every single time. And you hope that people are paying attention and have noticed that, oh, by the way, that longtime judge that you've been voting for got suspended. So attorneys for the Ohio Disciplinary Council, which is the arm of the Ohio Supreme Court that investigates attorney misconduct, recommended the suspension on Friday following the state's Board of Professional Conduct following a 2-day hearing. So this was being done by the attorneys section of this because she is both an attorney and a judge. So Carr is accused of issuing arrest warrants to people who didn't show up to her court despite the fact the court was closed during the coronavirus pandemic. So that's the first and most obvious one. People didn't show up to court. She issued bench warrants for their arrest, but they didn't show up because the court was closed. Carr lacks the judicial temperament required to function as a jurist. Attorneys Joseph Caligari and Michelle Hall wrote, they are disciplinary counsel attorneys, and her callous dishonesty casts serious doubt on her ability to serve in a profession grounded on the principles of truth and integrity. The severity and scope of her misconduct are unprecedented in Ohio. And notice they say that this is a profession grounded on the principles of truth and integrity. I know a lot of people think of the legal system as being a mire of fraud and twisting the truth and so on. But you do want the judge to be honest and have integrity. We've discussed this before about the appearance of impropriety. It's not that we simply require them to avoid impropriety. They have to avoid the appearance of impropriety. One step removed. And so here, they're actually saying that she lacks the judicial temperament, but she's also callous dishonesty. Callous dishonesty. And so if I told you, and you go in front of a judge today, the judge is dishonest. No doubt about it. The judge is dishonest. You'd go, wait, I don't want to go in front of that judge. The board will make a recommendation to the Ohio Supreme Court, which ultimately makes decisions on how to punish attorneys or judges for misconduct. Carr's attorney argued in a recent filing that Carr should receive a stayed 2-year suspension, meaning she wouldn't really be suspended unless she violated the terms set by the court, the Supreme Court of Ohio. And that would include mental health treatment and no further misconduct. And the question is, since it's being raised by her attorney, this concept of mental health treatment, it makes you wonder if there's something going on there too. He wrote that Carr suffered from a mood disorder due to several factors, including untreated sleep apnea and an anxiety disorder. She's now receiving treatment and has made significant strides, her attorney wrote. He also argued that she had no prior discipline actions in 27 years as an attorney and nearly a decade as a judge. And 57 people, including court staff and attorneys, wrote letters praising her and sent them to the board. And this is one of those things I've always wondered if anybody is swayed by those letters written by friends and family. And you say, Steve, those aren't friends and family. Well, they are. They are. It says here, court staff and attorneys. So if you're a court staff and you work for her and you write a letter that says, hey, she's a great person. I've worked with her. I'm her secretary. I'm her legal clerk. I look at that and go, okay, you work for her and you're writing nice things about her. Number one, did you write this on company time? And number two, how much how much stock can I put in this? So another quote here, Judge Carr engaged in the misconduct while suffering from undiagnosed physical and mental health conditions, which contributed to her actions, and once diagnosed by a qualified mental health provider, she engaged in and continues to engage in a sustained course of successful treatment, which actions engaged by her has caused her therapist to opine that she can currently, competently, and ethically engage in her duties. Again, that's her attorney writing, but you'll notice that he does say that Judge Carr engaged in the misconduct. And, he might not have been able to write that any more delicately, but one thing attorneys often try to do is avoid putting anything in writing where they actually admit that their client did something, unless it's been carved in stone and proven. So if your client's been found guilty, you can say, well, my client was found guilty. You don't say, my client did it. But like I said, the statement begins with, Judge Carr engaged in the misconduct. Not the alleged misconduct, not the stuff people are complaining about. Carr, during a 2-day hearing in front of the board, stipulated to committing the misconduct according to records. So the judge, Pinky Carr, agreed and said, yes, I committed misconduct. That was stipulated to. As her attorney, I think I'd still have tap danced around that, but that could just be me. Carr later lied in interviews, a reporter for WJW-TV and Administrative Judge Michelle Early, about issuing the warrants, the disciplinary record said. So apparently the warrants being issued for people who didn't show up when court was closed was covered by local television. And when asked about it, she lied about it. And so that's a problem also. Because again, she's not on the bench, but if you read the ethical rules for attorneys in most states, it says that you cannot make false statements of things when speaking to a client, when speaking to a court, or when speaking to the general public. So that's an issue. The investigation culminated in a complaint that is 118 pages long. 118 pages long. It's like a small book. Among other things, it found Carr, since 2017, illegally issued arrest warrants in order to make people pay fines and costs in order to generate revenue for the court. So someone comes before her and she orders them to pay fines. They don't pay the fines, and she would then issue an arrest warrant for that person. She also once sentenced a woman to 15 days in jail for rolling her eyes. So the judge said something the person didn't like, and the person did that, and she threw the woman in jail for 15 days. Now, as an attorney, I always suggest to my clients that they behave in court and when speaking to the judge to be respectful, because that'll help you. Rolling your eyes at the judge can only hurt you, but I wouldn't expect it to hurt you by sending you to jail for 15 days. I would not expect it. That's crazy. Another man got 60 days in jail for an offense that didn't call for any jail time, according to the filing. Now, it doesn't say what that was here, but if you look at the laws will often say, if you do this, you face a sentence of this. If you do this, you face a sentence of this. And the sentences are often a range. It'll often say, up to 30 days in jail. So the judge sentences you to 35 days in jail for something that calls for no more than 30. The judges overstepped their bounds. So if the law says if you break this, you pay a fine, if she throws you in jail for it, she's overstepped her bounds. That is, again, that's just straightforward. The disciplinary council also wrote that they found a daily pattern of the judge making false journal entries, improper plea bargaining, improperly speaking to only one side during a case, making arbitrary decisions, and treating her staff, lawyers, and defendants rudely. Now, let's back up. The false journal entries, I suspect they're talking about legal documents. And again, every state's got different terminology for this stuff. But if you ever go into a district court in Michigan on a day where the judge is handling a lot of drunk driving or traffic cases, the judge will call a case and he'll take the file, or she'll take the file and open up the file and start looking at the file. And in the file is the complaint or the ticket and the documents that are part of the court file, the court record. That's the court file. And a lot of times when the judge issues the ruling and the case ends and he's about to call the next case, you will see him or her taking a writing utensil and writing inside the file. And what they're writing is notes for the court clerk to indicate what you were sentenced to indicate what you were, how much your fines are, and to indicate anything else you may have to do as part of your processing out. So, indicated that she had a daily pattern of making false journal entries. I suspect it's something similar to that. The improper plea bargaining could be a lot of things, but improperly speaking to only one side during a case. They refer to that as ex parte communication. And so it's not uncommon that there's a judge, there's two parties who each have attorneys, and one party's attorney wants to speak to the judge in chambers, okay? They will often approach the bench with the other attorney and say, Your Honor, can we speak to you in chambers? The judge will often say yes, or say, well, let's just, can we do it out here, save some time? And the judge will talk to one party while the other party's right there. But speaking to one party without the other party present about a case where there's another party is an absolute no-no. It is so, this is like, I've mentioned before jokingly, something's law school 101. You learn it on the first day of law school. This is something you should know before you go to law school. The two attorneys writing this for the disciplinary action wrote, all the while, respondent ran her courtroom more like a circus than a respected hall of justice, presiding over cases with no regard for the law, due process, judicial impartiality, or professionalism. And that right there is a statement of condemnation unlike anything I've ever seen written about a judge. A judge. All the while, she ran her courtroom more like a circus than a respected hall of justice, presiding over cases with no regard for the law, due process, judicial impartiality, or professionalism. And that was written by the two attorneys after conducting an investigation. And some people are going to say, Steve, I'm glad you're doing the story, but she only got suspended for 2 years. That is, in my mind, short also. I agree with you on that. Somebody who does this much bad stuff and has it described like that by professionals shouldn't be a judge, period. So, Patrick, George, and Dennis, thanks for sending it. Cleveland.com. And Adam Faris wrote a great article. Cleveland Judge Pinky Carr should be suspended 2 years for unprecedented string of misconduct, according to the state disciplinary attorneys. And, of course, the final ruling will come from the Ohio State Supreme Court. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If you change the way you look at things, the things you look at change.